Your Honor, this case is about requiring a government agency to follow the law. The Iowa Racing and Gaming Commission is accustomed to many discretionary determinations, but it operates under a set of statutory commands and constraints set by the Iowa legislature. The commands and constraints relevant to this case, particularly the ones having to do with electoral approval of the licensing process, are not confusing, they're not obscure, and they have not been complied with in this case. Judicial review exists to correct that error, and we're asking this court to review and reverse the decision of the Racing and Gaming Commission that it took on February 6th to grant a license for the casino in Lynn County. I will not, in the amount of time allotted, be able to discuss every issue and fine point raised in the couple hundred of pages of briefing. I will hit what I believe are the most important points from our perspective. But to the degree that I don't cover something that the court has on its mind, I certainly invite questions or redirect so that I'm addressing the things that the court wants to know about. I want to start with the question of whether or not our two clients have standing to bring this action. Standing is purely a question of statute under the Iowa Administrative Procedure Act. Whereas in other areas of law, it is in part common law or a pastiche of different statutes, here it is entirely determined by the statute that I've got on the screen, which provides that a person or party who has exhausted all administrative remedies, which everyone agrees has happened, and who is aggrieved or adversely affected by any final agency action is entitled to judicial review. The effect of the proposed casino, once it is built on the petitioners, is substantial and is not disputed. Whether one looks at the studies that were done recently assessing the economic effect on surrounding casinos, or the studies done in 2014 or 2017 addressing the same question, or the affidavit of Carlin Allendick, one of the leading officers of our client, Riverside, it's plain that the Cedar Rapids Casino would cost Riverside tens of millions of dollars and the Riverboat Foundation at least hundreds of thousands of dollars. There is a controlling case, the Iowa Bankers case, that essentially resolves the question of whether or not there is standing in this case. And importantly, it is a case under this statute. Under Iowa Bankers, it's clear that a business competitor who is damaged by an act of a regulatory agency that directly affects and helps another business competitor, that business competitor who is disadvantaged has standing, and has standing even if the injury is probable as opposed to certain, even if it has not already happened. And one of the things that Iowa Bankers established was that the court does not import any federal principles or any principles outside of the IAPA in deciding about standing. The respondents have advanced no substantive distinction between Iowa Bankers and this case. About the only thing they're able to say about it is, well, you haven't cited a case about gaming. But they give no principle for why there is a difference between the gaming industry and the banking industry or the medical care industry in the Medco case, which is also directly on point. There is also no issue about what in the standing world we sometimes call traceability, about whether or not there is a certain necessary linkage between the action of the administrative agency and the the effect on the petitioner. Traceability for standing in a 17A action is simply not a requirement under Iowa law. But even if it were, Iowa cases clearly establish that there is enough of a link between the action of the Racing and Gaming Commission and the damage to the petitioners here. The best case to look at regarding that is the Puntenny case. That's the case having to do with the Dakota Access Pipeline. There the question was whether members of the Sierra Club whose enjoyment of and concerns about nature would be damaged by a pipeline had standing to seek judicial review, not of the construction of the pipeline, but simply judicial review of the permit that enabled construction. And the Supreme Court recently said, yes, they did have standing, that they were sufficiently well affected, that there was an adequate nexus under the statutory language. The only case that the respondents cite in opposition to this is the Shenandoah case. The Shenandoah case is inapposite for a couple of reasons. First, it's not a case decided under the Iowa Administrative Procedure Act, and so the body of law under which Shenandoah was decided is different. Second, it was principally decided not on standing grounds, but on ripeness grounds. And the Punteni case and others, all coming well after Shenandoah, represent the current state of the law on this. The next thing that I'd like to talk about is the statutory authority question. And I first want to talk quickly about what statute governs, because there is a provision that is critical to this entire inquiry. The entirety of 99F.711 controls the outcome in this case, and that statute starts out with this language: a license to conduct gambling games in a county shall be issued only if the county electorate approves the conduct of the gambling games as provided in this subsection. And I want to focus on the words "this subsection," because at least in the Racing and Gaming Commission's briefing, they float the idea that subsection doesn't really mean the entirety of the statute. I've got the entirety of the subject on the screen now. That is the subsection, and every part of that, paragraphs A through E, are what that language that I just read, that language that only if it's complied with can a license be issued, all of that is required here. There is some effort to argue, oh, no, only paragraph A matters, as though the legislature was somehow confused when it used the word subsection. I'm not going to go through these in detail, and we will, if the court desires, make the entirety of the PowerPoint available to the court afterwards to refer to. But my point here is, and we've cited a number of statutory provisions, the point is, whether it is the word chapter or section or subsection or paragraph, all the way through 99F, the legislature is very consistent in how it uses those terms, and the thing that we're looking at in 99F711, that is the subsection. It's not simply part A of that. And in the PowerPoint, I'm not going to go through all of them, but there are various cross-references that we've shown to demonstrate how contextually subsection means that entire statute. Under that statute, the ballot submitted to Linn County voters in 2021 was defective. It was defective in a couple of different reasons. First, it was defective because it led the voters to believe that gambling already in some form existed in Linn County, and that what they were being asked was to decide whether or not to continue that gambling, not to initiate new casino gambling. The text of the referendum, and this is not a summary, this is not an inoperative part, this is the thing that they were voting on, said, if approved by a majority of the voters, operation of gambling games with no wager or loss limits may continue. The definition of the word continue is undisputed. Continue can only mean something that is already going on, continuing, or remaining in effect. It can't be a new thing. Paragraph D of the subsection is the place that this court looks to see whether or not the ballot complies with the law. That paragraph required Linn County to propose to the voters, and I quote, a proposition requiring the approval or defeat of gambling games. In a county where there was no gambling going on, a proposition requiring the approval or defeat of gambling games has to be a proposition asking the voters to approve the commencement, the initiation of gambling. It can't be a ballot asking them to continue existing gambling where there was none. Moreover, The ballot says if disapproved by a majority of the voters, the operation of gambling games on an excursion gambling boat or at a gambling structure will end within 60 days of this election. The word end also has a very plain and undisputed meaning. It means something is going on and we're going to stop it. And by the way, the language there that says we'll end within 60 days of that election, that was legally erroneous. That's not actually what would have happened even if there had been gambling going on in Lynn County. The 60-day statute had been read out of the law many years earlier. We're told, well, the voters knew that there was no gambling in Lynn County because the media had talked about things and there was a derecho and a flood and all these sorts of things, and so it was top of mind to voters, and so they knew whether there was gambling or not. But they may have known different things or heard different things from the media, but here, the county government, the government that is asking their opinion is, through the two statements that I've got on the screen here, telling them gambling is going on in Lynn County. And so it's misleading them, and as we discuss in our papers, given that there was less than a 10% margin in this election, only 1 out of 20 voters would have to have been misled to change the outcome of the election. Now, we don't need to win that the outcome of the election was erroneous. We only need to demonstrate that the ballot didn't comply with the statute. But the backdrop of this and the closeness of the election shows why compliance is so urgently important. There's another problem. Gambling games with no wager or loss limits. In a couple of different places, the ballot is telling them that they're voting on gambling games with no wager or loss limits. That is a subset of all of the different kinds of games available. The commission, statutorily, is empowered to decide whether there will be gambling games with limits or without limits. And the respondents suggest, oh, gambling games with no limits and no wager limits, no loss limits, that represents the entirety of the Venn diagram. That represents all the gambling there can be. That's not correct, because we're not talking about what games the casino chooses to offer. We're talking about what games the commission decides to license. And it is the commission's decision, not the decision of the voters, what games will be licensed. And when the commission makes a decision, it can decide to have unlimited games or it can decide to have limited games. The court is from the east coast of Iowa and well remembers the days when there were limited games on riverboats. That's still within the IRGC's arsenal, but this ballot measure purported unlawfully to take that away. Additionally, as the court pointed out in the ruling on the stay motion, the targets for where the voters direct their attention to cast their ballot come right after all of the troubling language that I just decided, further aggravating the confusion about this ballot. The voters approved operation of gambling games may continue and gambling games with no wager or loss limits. The word new on the left side, that's a typo, that shouldn't be there. But what they got was construction and operation of a new casino where gaming did not exist. And what they got was operation of gambling games with or without wager or loss limits when there was no such adoption of all of the different kinds of gambling proposed to them in the election. And so there was a divergence between what the voters were needing to approve to authorize a license and a divergence between the license itself and what was contained in that ballot. As a refuge, the respondents say, well, all we needed to do was have substantial compliance with the statute. We didn't need to have strict compliance. I would argue first that the defects in this ballot that we've described here are defects so fundamental that they are the kind that would be substantial defects. In other words, substantial compliance does not rescue the problems with this ballot. We would start with the Hanahan case. That's the case in which the thing that was voted on, the thing that was on the ballot, was whether or not to build a new senior high school. but the thing that was actually sought to be done, and the thing that after the election the school authorities wanted to do, was to build a schoolhouse. And the schoolhouse was perhaps K through 12, perhaps 5 through 12, but it wasn't just necessarily limited to a high school. And the Supreme Court was very clear that it was reviewing this matter for substantial compliance, not for strict compliance. But nonetheless, it stated that this was a blatant error that went to the very heart and soul of what the electorate was being asked to decide. The errors that we have shown on the ballot that I just went through, those two are blatant errors that go to the very heart and soul of the ballot initiative. Similarly, the Brown versus Carl case, also reviewed under a similar standard way back at the turn of the last century, compared a proposition to issue bonds versus a proposition to actually build a plant. And again, the court found that that was insufficient compliance with the governing law and that the exact question had to be proposed to the voters. The respondents proposed an alternative case from the 1930s, the Remsen versus Johnson case, because that case had the word extend in it. And they try to excuse the word continue in the present ballot by saying, well, the word extend was in this ballot in Remsen versus Johnson, and the Supreme Court tolerated that and thought that it was an immaterial variance from what was actually going to be done, and so no problem there. What they leave out is that in the Remsen case, before the word extend were the words on the ballot purchase, establish, erect, and extend. And so the ballot was telling people that they were going to finance the power plant, build the power plant, and then continue the operation of the power plant. If all that had been voted on in Remsen versus Johnson was whether or not to extend the power plant, and those other words hadn't been there, surely the case would have come out differently. And that's what should happen here. I will say, though, while I believe it's obvious that there is not substantial compliance with the words of paragraph D of the material subsection, this is not on these facts a question or a proposition that approves or disapproves gambling. I do think strict compliance is the rule here. And the court need look no further than the very first sentence of subsection 99F711 that says, for these electoral requirements, only if they are complied with as written in this subsection may the Racing and Gaming Commission issue a license. That only if language is as strong as the legislature ever gets. Stronger, I would submit, than shall. Stronger, I would submit, than must. It is the most restrictive way that the legislature could say you have to do what this statute says. The Racing and Gaming Commission is proud of the discretion that it has to make decisions essentially unreviewably. This is not one of those times when it has such discretion. This is rather purely a question of law. All this court is going to do in deciding whether or not subsection 99F711 has been complied with is it's going to take that ballot that we were just going to look at, or just looking at, and it's going to take the statutory subsection that we were looking at, and it's going to look at the two of them, and it's going to decide whether or not that ballot meets the statutory requirements. There's no witness testimony. There's no evaluation of soft or economic sort of circumstances or anything like that. It is purely an exercise of analyzing words on one document and another document and seeing whether or not those words fit. In that circumstance, the agency is entitled to no discretion. And that's what 17A says. 17A 1911 sub B says that this court, in this proceeding right now, should not give any deference to the view of the agency with respect to particular matters that have not been vested by a provision of law in the discretion of the agency. And so the question is, has the interpretation or the meaning of that statute been vested by a provision of law in the discretion of the agency? And the answer is, no, it has not. Now, first of all, when the court looks at subpoint A up above that, what subpoint A tells the court is deciding whether or not the legislature has vested discretion in the agency. That's something that the agency doesn't get any deference in. The agency, of course, doesn't get discretion to decide what its own powers are. But secondly, on these facts, we have an Iowa Supreme Court decision that tells us that the agency has no ability to use discretion in interpreting the statute. First of all, well, I'll go here first, and that is the Kopecky case. Kopecky was a case that actually dealt with this exact statute, 99F7 sub 11, the subsection that we care about, and the court looked to see whether or not there was evidence in the statute that the legislature intended to vest in the agency discretion to interpret that provision, and the Supreme Court said, no, it does not. The agency has no discretion to interpret that law. The only comeback to the Kopecky case from the respondents is, well, Kopecky was a rulemaking case, and this wasn't rulemaking, this was other agency action when the Racing and Gaming Commission issued the license. But the fact that it was other agency action doesn't change the nature of the statute. It doesn't change whether or not there are clues in the statute saying that the legislature intended to make this discretionary on the part of the regulator. Indeed, there is no distinction between rulemaking and other agency action for the purposes of statutory interpretation, because a statute is a statute is a statute. It doesn't mean one thing in one procedural context and a different thing in another. I know the court went to the University of Iowa at the appropriate time. Maybe the court actually studied under Professor Bonfield. But Professor Bonfield is the oracle, if you will, about the Iowa Administrative Procedure Act. And I've got, there's a Polestar article of his about the last set of substantial amendments to the IAPA. And one of the things that he says is that normally the interpretation of a statute is a pure question of law, over which agencies are not delegated any special powers by the General Assembly, so a court is free to, and usually does, substitute its judgment de novo for that of the agency and determine if the agency interpretation of the statute is correct. The Renda line of cases that we cite in our briefing is the embodiment of what Professor Bonfield says there. And Kopecky actually is one of the steps in the Renda line of cases saying that agencies do not, absent a clear signal from the legislature, have the ability to interpret their own statute. Even though, or let's say that this is a question of application of law to fact. That's the suggestion that is made, I think, in the Racing and Gaming Commission's brief, that this is an application of law to fact. Even if that were true, the commission is not entitled to get the law wrong. Similarly, let's imagine that this is even reviewed for abuse of discretion. I think it's plain under the authorities and under the statute that this is reviewed for errors at law, reviewed de novo by this court, because this court is sitting in an appellate capacity. But let's say that that's wrong. Let's say that this is a review for abuse of discretion. It's black letter law in the appellate field that if you get the law wrong, that is an abuse of discretion. And the whole issue that we're talking about here is the agency's misinterpretation of the law, misinterpretation of whether or not that ballot satisfied paragraph D of the subsection. And in fact, the commission knew that, because on February 6th, when the commission granted the license, the commission devoted exactly 2 sentences to slapping down the argument that we made in a very detailed filing about why, as I've argued here, the ballot was defective and they couldn't grant a license. And Chairman Olson says, I will start here and say that we are aware of the argument that the commission doesn't have authority to grant a license because of the wording of the 2021 referendum in Lynn County. But just to address that up front, after consulting with our legal counsel and representatives from the AG, the Attorney General, a majority of the commissioners are satisfied that we have the authority to move forward to make this decision. They didn't deal with this in detail, but they were aware of it, and they ruled on it, and they ruled that they had the authority. But how did they rule that they had the authority? They didn't say, we commissioners decided and used our discretion. They said, this is a law question. We had to talk to lawyers to find out what we could do, and the lawyers told us we could do it, so we're doing it. So even the commission itself agrees that this is a question of law, not a question of fact, not a mixed question, not a question that is reviewed for abuse of discretion. A novel argument that has been advanced lately is that the 2021 referendum was not in fact required. That based on the 2013 referendum, the Racing and Gaming Commission could issue the license and they could just forget about the problems with the 2021 referendum. The parties take somewhat different views of this. As I read it at least, the developer contends you never had to have the second referendum, whereas the Racing and Gaming Commission says, well, yeah, you had to have the second referendum, but you could do it sometime after you issue the license and build the casino. Regardless, they're both wrong. The statutory language is very clear. Remember, first of all, that the commission can only issue a license if the electorate approves as provided in this subsection. And so there's the initial election that is provided for in paragraph A. And then if that election is successful, they can issue the license. That happened in 2013, but 8 years went by and they didn't issue the license. So then you get to paragraph D. Paragraph D says that if the first election was approved, then the Board of Supervisors shall, not may, not could, shall submit a proposition requiring the approval or defeat of gambling games to the county electorate as provided in paragraph E. This is the thing that made this 2021 election mandatory. And the thing that made it mandatory after 8 years is subsection E. E is the thing that says that had to be complied with, and that's the thing that gives the timeline. Although we don't have to be right about the 8-year timeline for this court to nonetheless reverse what the commission did, although we think that the 8-year requirement is the right way to read the statute. The respondents argue that everything that I've got on the screen right now, paragraphs D and E, you could just ignore it. That you could have, a dozen years later, used the 2013 referendum. You didn't have to have the 21 referendum, or you could have it at some later point. The respondents do not, unlike what we're doing here, advance any argument from the text of the statute that says shall in paragraph D means may. They don't argue anything from the text of the statute that says after the first approval that there is a forever green light unless there is another referendum that disapproves. In fact, the commission talks about a disapproval election as though it's some sort of different election or different kind of an animal from the approval election. They're not. There's only one kind of election. It's an election to approve or disapprove gambling games. It's all the same kind of election. The commission also argues that you only need to have the second election if a casino is built. They make no argument from the text of the statute of how you get there. Both parties talk about some sort of safe harbor thing about how they had this election in 2021 so that they could avoid having a third election. There's no argument from the text about a requirement for a third election. There's after 2011, when the statute was amended, there are two elections. There's election number 1 and election number 2. In 2021, they did election number 2. And even if election number 2 could be later than 8 years, it can't be later than after a casino is built in reliance on an election many years earlier. In that case, the second election could be 2 years, 10 years, as we jocularly put it in our reply brief, 500 years later than the construction of the casino. The obvious purpose of the legislature here is to have a reasonably contemporaneous litmus test of public sentiment close in time to when you're going to issue the license. Their reading of the statute allows a license to be issued based on an evaluation of public sentiment decades in the past. The legislative history of this before the amendment of the statute was there were elections every 8 years. All counties with casinos had to have elections in 94, in 02, in 10. The legislature in 2011 decided that that was burdensome and did away with the repetitive election requirement, but the 8-year gap didn't go away, and that's why the 8-year gap is there in subparagraph, or in paragraph E. But even if it doesn't have to be 8 years, it still has to happen. Remember that, and this is the language in the lower right-hand corner, the license shall be issued only if the county electorate approves the conduct of gambling games as provided in this subsection. The only way you can do that is by having a qualifying second election as subparagraph or as paragraph D and paragraph E provide. Moreover, even if they didn't have to have an election in 2021, Lynn County did. And they made a mistake. They botched the election. And so they can't now, based on these thin statutory arguments, pretend that the election didn't happen. The election did happen, and it happened in a misleading way, and it happened in a way that was really close, where a swing of one voter in 20 changes the outcome. And we have the unrebutted affidavit from Mr. Binder that says that people are comfortable with the status quo. In referendums, they tend to vote in favor of the status quo. This ballot told them a false status quo. And if even a handful of voters were misled, it changed the outcome of the election. Again, we don't have to prove a change in the outcome, but it does show the import of the mistake that was made here. Finally, this argument that they didn't have to have the referendum or that they could have it some distance in the future contradicts everything that has been said up until the resistance briefs were filed in this matter in March. So here's what the developer's attorney told the Racing and Gaming Commission when we had the hearing on the declaratory order. Is there a requirement for a second ballot, and must it be met in accordance with 99F? The answer to that is yes. So he, in oral argument, conceded that the second election was required. In petitioning to intervene in the declaratory order provision or proceedings, and I won't quote or read all these quotes, but over and over again, the developer's brief seeking to intervene treats the second election as having been required by the statute, completely the opposite position that they take today. The IRGC, in its refusal to issue the declaratory order, said if a county approves gambling games through a referendum, that county's Board of Supervisors must submit a proposition requiring the approval or defeat of gambling games to the county electorate again in a future election, and they quote paragraph D, the one that we're relying on. The county itself, in the documents authorizing the election, indicated that this was a requirement. When the county wrote to the Racing and Gaming Commission to oppose our petition for declaratory order, they talked about how Iowa law required a second referendum on gambling games to be presented to the Lynn County voters in 2021. What are the implications of all of this? First, the fact that they now say that the statute lets you out of the requirement for a second election just isn't very credible. No one was saying that up until about a month and a half ago. Secondly, no one advanced that position in these proceedings until we got to this court, and that's a waiver of the argument. This court is sitting in an appellate capacity. There's been no motion to expand the record or present additional evidence or anything like that. We're going on the record that was made before the agency, and in the record before the agency, there was no argument that the 2021 election was unnecessary. And at least for the developer, which was affirmatively advocating about this to the commission, they're stopped from taking this position. They took a diametrically opposed position to the agency in order to intervene in the proceedings earlier. They can't now do a 180 and say, oh, we didn't really mean it, now we're going to take the opposite position. But lastly, it shows that our interpretation of the statute is correct. It's the second referendum requirement is one that has been done by the casino license holders in all of these counties throughout all of the many years. And they're not doing it for fun. They're not doing it because they want to spend the money or go through it. They're doing it because they think the law requires it. And these different parties didn't say these things because they didn't care or were being reckless. They said these things because they thought that that's what the law required. All we're telling the court is that what everyone said up until these briefs that were filed in this court, that's what the law is. Everybody pretty much understood what the law is. They can't change that now. Unless the court has questions about what I've said for now, I will reserve my remaining time for rebuttal.
I have no questions at this time. Thank you.
Thank you, Your Honor.
Council, I'm going to take a 15-minute recess so that anybody that might want to use the restroom can do so. And there's restrooms down on the basement floor for males and females, and there's also a restroom in this hallway back here. If you want to use that one, ask Carrie for permission to go back there, and that'll work. So let's start again in 15 minutes. Thank you.
I told you I wouldn't make 30 minutes.
I know, I was looking for one.
be seated. Thank you. All right, the record will show that all good people are present and accounted for. And Mr. Peter Zalek, whenever you're ready, you may proceed.
Thank you, Ryan. The Iowa Racing and Gaming Commission is a legislatively created, executive branch appointed body that has exclusive jurisdiction over gambling in the state of Iowa. They're the ones that control licensing. They're the ones that control all aspects of this highly regulated, highly complex industry. And that's important to know at this juncture, I think, Judge, because a couple of things have changed since the last time we were before you. One of those things is that you now have the benefit of the record that was developed before the commission over many months of the licensing process. I don't know how, like there's 19 volumes that were submitted to the court for review. These are all things, all the facts, all the submissions that were submitted to the commission for its review. And as you've already alluded to, Judge, you already have the benefit of close to a couple of hundred pages of briefing on the merits that you haven't had before. Those are two things that have changed. But what hasn't changed, Judge, is the unprecedented demand from the Washington County petitioners that you disenfranchise 44,311 Lynn County voters. 44,311 Lynn County voters, over 24,000 of whom voted in favor of continuing to approve gambling in Lynn County, Iowa. Why should you change the outcome of this election? Because, as the Washington County petitioners assert, it's because the people who live in Lynn County, who educate their children in Lynn County, who seek entertainment in Lynn County, don't know enough about what's going on in their community to accurately vote on this petition in 2021. That is a breathtakingly audacious position to take, to nullify an election from 2021 as we sit here in 2025.
Could I ask you to put your mic on? Maybe have it on, it's not turned on.
How's that?
That was perfect, thank you.
The Washington County petitioners don't stop with just asking you to nullify the 2021 referendum in Lynn County. They go on to then argue and assert that you also have to strip the Racing and Gaming Commission of its exclusive authority to issue licenses to facilities that follow the application process to comply with the laws and regulations, that you have to strip them entirely of any ability to issue a license in Lynn County. That premise, those arguments are not supported by the facts in this case, they're not supported by the law. When we go through and explain to you how the framework is designed, how it works in operation, it'll be clear that the Racing and Gaming Commission's decision to award a license in Lynn County should be affirmed. Just as a point, a jumping off point, Judge, we're here on a petition for judicial review. As you sit on the bench today, it's a little bit different than normally what you would be doing when you're sitting on the bench. You're sitting in a purely appellate capacity. You look at the record that was before the commission, you look at the arguments in the briefs, and there are several things that we'll be talking about with respect to deference and standard review as I go through my argument. But one thing that's important to note at this point, and I'll bring it up again, and I noted it at the very beginning of my argument, is that the Racing and Gaming Commission, they are the subject matter experts on racing and gaming, particularly gaming in this case in the state of Iowa. That's what they're appointed to do. They're appointed to regulate this highly complex, highly regulated, multi-billion-dollar industry in the state of Iowa. That's what they're here for. The petition for judicial review is broken up into three
separate counts. And I think it's probably easiest for me just to go through those counts one by one as we explain our position in this matter. Count 1 is a count that challenges the authority, directly challenges the authority of the commission to issue this license. As a matter of law, the only way the commission can be deprived of its authority to issue a license in Lynn County is if the voters in Lynn County unequivocally vote no. No, we don't want gambling. We'll go through and explain how that works with the statutory framework, but keep that in mind. Number one, the voters have to say no. Number two, voters in Lynn County have never said no to gambling in Lynn County since the 2013 referendum. The 2013 referendum, which is the jumping off point here before we get into the 2021 referendum, nobody's arguing authorizes the commission to issue a license at that point in time. In fact, I think virtually every casino in the state was licensed after one referendum. In fact, the commission considered several license applications. One in 2014 was a consideration, and another round in 2017. Clearly had the authority to issue licenses after that first referendum in 2013. They considered the applications, and at that point, even though it was not a unanimous vote either time, ultimately those applications were rejected. As we go through Chapter 99F, particularly 99F7, we'll take a look at how this works in practice. 99F7.1. You'll see as I go through these slides, contrary to Mr. Weinhardt's assertion, I'll be going through 99F7.11D and E, but we're going to start with the beginning. We're going to start with 99F7.1. If the commission is satisfied that this chapter and its rules adopted under this chapter applicable to licensees have been or will be complied with, the commission shall issue a license. I underline if the commission is satisfied. That's because it's not if the court is satisfied if their rules and statutes have been complied with. It's not if Washington County was satisfied. It's not if Lynn County was satisfied. It's if the commission is satisfied that 99F is complied with as well as its administrative rules. Two things to bring to your attention, one of which Mr. Weinhardt mentioned, one of which he didn't. One is we go through and you'll see that the commission's addressing of these applications was an application of fact to law. That directly implicates the deferential standard of 17A 1910 subparagraph M. The other part is whether deference was vested with the commission itself. I'll point you again to the very first sentence in 99F7.1. If the commission is satisfied, that directly applies to Renda, which I have cited there, and it directly applies to a case that, the Putenny case, which the Washington County petitioners cite for a different purpose. They cite it for standing, but in that case, it was the Iowa Utility Board who was addressing the matter, another entity that addresses complex matters in a highly regulated industry. And the Supreme Court made it very, very clear that the way it was worded, the phrase implies that the board determines whether the dictates of that statute have been complied with, just like it says if the commission is satisfied. If that wasn't in there, as they point out in Putenny, it would just say this chapter and rules adopted must be complied with. That's not what it says. It says the commission is satisfied. I think this might be a good point to weave in a point that Mr. Weinhardt made with respect to the Kopecky case. I want to note several things with respect to Kopecky. First of all, if you go to the very top of the Kopecky case, you'll see my name on there. That was my case. We dealt with it. And let me tell you what the Supreme Court said in Kopecky. The Iowa legislature, this is at page 442 and 443, the Iowa legislature has vested the commission with broad authority to regulate gambling operations in our state. The legislature has empowered and obligated the commission to regulate all gambling operations governed by Iowa Code Chapter 99F. The commission has supervisory authority and full jurisdiction over all gambling operations governed by Chapter 99F. Under Chapter 99F, the commission has the exclusive authority to issue licenses. Ultimately, the legislature gave the commission the authority to decide the number, location, and type of gambling structures and excursion gambling boats under this chapter. Accordingly, we disagree with Kopecky and conclude the commission has the power to issue a license following an affirmative gambling game referendum, but is not required to do so. That's exactly what happened in 2013 with the passage of the referendum approving gambling. That's exactly what happened in the subsequent applications that were denied. There isn't anything about the 2021 referendum that has anything to do with the commission's authority, doesn't have anything to do with divesting the commission's authority to issue a license in Lynn County. (99F711A), if a majority of the county voters voting on the proposition favor the conduct of gambling games, the commission may issue one or more licenses. That happened in 2013. That gives the Racing and Gaming Commission full authority, as we just read to you from Kopecky, to issue a license if they choose, and otherwise if they're satisfied that it meets the requirements of the chapter and their administrative rules. And if you take that overview of 99F7 and then move on to 99F7A, I don't think there's any disagreement at all that the 2013 referendum gave the commission the authority to issue a license, and as noted before, that oftentimes happens where a license is issued right after the initial referendum. So now let's move into the issue with respect to the 2021 referendum. As I noted before, we're not hiding from any language in 99F711D or E. I'm going to walk you through those, Judge. The one thing that I want to point out in 99F711D and E, there's not anything in either one of those sections that says that the commission's authority expires in 8 years, that they turn into a pumpkin in 8 years, that they have to go away in 8 years. And if you read the statute in its entirety, that makes perfect sense, because there's also the ability in that second referendum for the voters in Lynn County, in this case, to vote against gambling, in which case the commission would not have authority to issue a license if there was a no vote. All of a sudden, after 8 years, the commission doesn't all of a sudden get its authority back. The 8-year notion is simply made up. It has nothing to do with the commission's authority to issue a license in this case. That authority is derived from the 2013 referendum and continues. Now, to be fair, at some point a referendum has to be held. The second referendum has to be held. It just doesn't have to be held in the manner and the time that the petitioners assert. The purpose of the 2021 referendum in this case, or a subsequent referendum, is really more or less of a check-in. A lot of times there might be a casino already existing and they're going to ask the electorate, are you still okay with gambling? Same thing here. They approved gambling in Lynn County in 2013, 2021, electorate in Lynn County, are you still okay with gambling? There isn't any way to look at the vote of over 24,000 Lynn County voters who voted in favor of gambling and say those 24,000 plus yes votes are an unequivocal no vote. That's the only way you can ever deprive the commission of its authority to issue a license in this case. You would have to convert 24,000 plus yes votes into no votes in order to deprive the commission of its authority. And we all know that did not happen. We all know that cannot happen. As we've argued in our briefs, the real purpose of the 2021 referendum, and it's this real purpose that is evident in other counties, is if you have the referendum in 2 successive elections, you don't have to have any more referendums. It's just a safe harbor. You can do that. There isn't any requirement that you have to do it at that particular time. But say if they hadn't done it in Lynn County, they're still going to have actually probably 2 more referenda in the future to have 2 successive elections in order to get the safe harbor. That's significant because for another reason that maybe we haven't fully thought about. Even if the election hadn't happened, even if you nullified the election, Judge, it doesn't matter. They can still have another referendum and a subsequent referendum. The point is, it does not deprive the commission of its authority. That really brings us to the point where we get to the commission considering the 2 things that they primarily considered in this case. One, did the 2021 referendum, was it in fact a no vote? And then whether the commission was satisfied. Remember, it's the commission that's satisfied that 99F and its rules have been complied with. How did the commission do that? They did that by taking in all of that information that we've already talked about, the 19 volumes of information that is now in front of you. They had site visits in Cedar Rapids. They went to Cedar Rapids and talked and invited public comment during that period of time. That's where they gathered their facts. That's where they applied those facts to 99F711, 99F71 to satisfy the commission that the rules and statutes have been complied with. There's a pure application of facts to law, which invokes the deferential standard of Chapter 17A, in which you can only reverse the decision of the Racing and Gaming Commission if it was irrational, illogical, or wholly unjustifiable. Maybe stating the same thing but a little bit differently, if they're looking at interpreting whether or not a legal standard within their statute has been met, a legal standard, whether they have been satisfied, whether the election was appropriate, that again is a pure set of facts to law. They looked at the box of issues around the election, they looked at their law, they came to the conclusion that they did. Unless that conclusion somehow becomes 24,000 plus no votes, the commission retains its authority to issue a license in this case. We're talking a little bit about the facts that the commission considered in coming to its decision. And I want to emphasize a few of those, Judge. As I mentioned before, the commission traveled to Lynn County, they traveled to Cedar Rapids, they made site visits. But what I want to mention to you, Judge, is they invited public comment from the people who were in the area, the people who could be affected by this casino. In person, they had over 100 people appear before them and make a public comment. People on both sides of the gambling issue. Yes, we want gambling in Cedar Rapids or Lynn County. No, we don't. People on both sides of the issue. Do you know how many people said that they were confused by the 2021 ballot? 0. Do you know how many people said they were somehow misled by the 2021 referendum? 0. After the public comment period in person, the commission invited written comments. Many, many hundreds of people, again, on both sides of the gambling issue, commented in writing to the commission. Hundreds of them. Not a single person said they were confused by the language in the 2021 referendum. Not a single person said they were in any way misled by that language. Again, people on both sides of that of the issue of gambling itself. And then we look at, as the commission did, at the ballot itself. It's a substantial compliance issue, even if you were going to apply election law, which we don't. It's whether the commission was satisfied that its statute was complied with and its rules were complied with. The very first part of public measure, gambling game, the summary, gambling games on an excursion gambling boat or at a gambling structure in Lynn County are approved. Is there anything about that summary that says that anything other than they're approved or not approved? The answer is yes or no. The majority of the people chose yes. We want gambling to continue in Lynn County. If you look at the first sentence of the ballot itself, the ballot language itself, gambling games with no wager or loss limits on an excursion gambling boat or at a gambling structure in Lynn County are approved. Again, clear approval. If they vote yes for that, if they vote no, not approved, they voted yes. Easy for the commission to decide that that was sufficient to evidence the Lynn County voters' desire to continue with gambling in Lynn County. It would be irrational, illogical, wholly unjustifiable to say that those 24,000 people that checked yes in that referendum actually meant no. That can't be done with the deferential standard. I would submit to you, Judge, it can't be done with any standard you apply. You cannot legally, factually get to 24,000 plus yes votes being no.
Let me ask you a question. So
Sure.
what you're telling me, if I understand it correctly, is it doesn't make any difference that the 2021 referendum talked about gambling games with no wage limits.
It does not make a difference, and that's a point that I was going to make in response to something that Mr. Weinhardt said. The universe of gambling games is the gambling games without limits. Gambling games with limits, other gambling games are a subset of that. What Mr. Weinhardt is arguing is that that the universe that we reside in, that our solar system is in, what Mr. Weinhardt is arguing is that the universe is a subset of the solar system. That's completely the opposite how it works. The voters in Lynn County, based on that language, clearly approved the full panoply of gambling games that were available without any restrictions. They wanted gambling to continue. So that language, if anything, actually supports our position as opposed to somehow confusing the voters or making them wonder what they were voting on. And again, you have to apply, as the commission did, facts to the law. Did a single person at any point from 2021 to 2025 come in and say, we were horribly misled by this ballot language. We didn't understand this ballot language. Not a single person said that. It's something that came about after the license was issued. It's a litigation position, and that's what we're dealing with today. Okay. I'm going to finish up here. I'm just about out of time for my 20 minutes. A couple of points I'll make real quickly. One, that with respect to standing, my friend Mr. Holscher from representing the Cedar Rapids Development Group is going to spend some time talking on standing. I'll make just 2 points on that. The cases that they rely on, the Bankers case, Association case, if you look at that case, 4 out of the 5 issues that were raised in that case, the Supreme Court decided that there was no standing on. It's a very limited holding, doesn't really help them at all. And then their argument with respect to competitor standing turns competitor standing on its head. Competitor standing is when a person wants to get onto the playing field and compete against others. The petitioner's position on competitor standing is, it's my playing field and nobody else can come on it to play. That is not competitor standing. No one's argued anything about the declaratory order. I think that's already been decided by the Commission's decision to issue it. And I just want to close with one point. We do have Commissioner Amy Burkhart here with us today, a person who resides in Southeast Iowa. And just a couple of points to end things. The Commission shall have full jurisdiction over and shall supervise all gambling operations in the state. That's 99F41. And Commissioner Burkhart, as she was going through and analyzing, if you look at 99F, every part of 99F relates to the benefits to the state of Iowa. It's not particular to the Washington County. It's not particular to Lynn County. It's the benefit to the state. And she very eloquently said, she's from Southeast Iowa, and this project comes nearest to her. But for her professional responsibilities to the Racing and Gaming Commission and for her own personal integrity, she has to put that aside. I'm an Iowan today and not representing a particular area and looking at the state of Iowa. All I see is net gain. There's a net gain tax-wise. There's a net gain, obviously, for Lynn County. There's a net gain across the board here. The commission's decision was correct, no matter what standard of review you want to use, but it is a deferential standard, and that should, the commission's decision on this issue should be affirmed.
Mr.
Thank you,
Jones,
Your Honor.
whenever you're ready, please proceed. Thank you.
Very good. Your Honor, my name is Sam Jones. I appear before you on behalf of the Lynn County Gaming Association. In many ways, this dispute feels more personal to my client and to me than I think anyone else appearing before you today. It's my client that seeks a gaming license that's at issue, and it's my client that will distribute the more than $6 million to community civic, charitable, and educational institutions in and around Lynn County. In some ways, Your Honor, it also feels as though I'm appearing before you on behalf of the Lynn County electorate, of which I believe I'm the only person here who can claim that. At its heart, this case turns on the assertion that the Lynn County voters were in some way confused by a 2021 ballot measure concerning the ongoing approval of gaming in Lynn County, and that the IRGC acted in an arbitrary and capricious manner when it considered the sufficiency of that ballot. The Assistant Attorney General has already spent a good deal of time discussing 99F and the ballot itself, but I view my job today as taking on any question of voter confusion directly. Gaming in Lynn County has been a hot-button issue for more than a decade. The initial ballot initiative approving gaming took place in 2013. That vote was highly controversial. Subsequent to that vote, there have been 3 separate applications to the Commission for a gaming license. Each application came with significant media attention. Each application was denied, and in turn, that denial received even more media attention. The 2021 election garnered equal, if not more, publicity. Lynn County voters knew of the issue when they went to the polls in 2021. I can assure you of that as someone who participated in that election. Your Honor, in front of you on the screen, you see the same Lynn County attorney letter that has been utilized by Mr. Weinhardt. I would note first, Your Honor, this is not some ultra-virus attachment to a brief in an effort to bolster a litigation record. Instead, Your Honor, the Gaming Commission requested public comment, established a schedule for submission of that of those comments, and in response, the Lynn County attorney submitted this letter. I think if you review that letter, which I hope Your Honor will do as part of his consideration today, you'll note that the Lynn County attorney tried to take on this issue of voter confusion directly. In his statements to the commission, the Lynn County attorney stated, when considering the historical efforts of more than a decade to establish gambling games and bring a casino to Lynn County, the voters of Lynn County were uniquely well informed. Both before and following the vote, no citizens or voters of Lynn County ever took issue with the ballot language or the election results. In addition to that letter, Your Honor, there were 420 other written comments that were submitted to the Gaming Commission, both in favor and in opposition to the license. Notably, none of those comments expressed confusion about the language of Public Measure G or suggested that others may have been confused by that language. Rather than producing any affirmative evidence on behalf of Lynn County voters, Riverside produced 0 affidavits, surveys, or complaints. Instead, petitioners have baldly asserted confusion, relying on a paid-for expert's written opinions. Significantly, the Gaming Commission received 0 comments about ballot confusion, even after Riverside's arguments regarding this ballot language received significant media attention. As noted earlier, Your Honor, gaming in Lynn County is a hot-button issue. The 2021 election was hotly contested, with many expressing strong opposition. Given the resources that Riverside has dedicated to fighting competition, first at the administrative level, then at the legislative level, and now at the judicial level, I think we can state with some degree of confidence that if there were Lynn County voters who did not understand what was at issue when they walked into the ballot box, you would have affidavits in front of you today, Your Honor. I think it is crucial to note that there was affirmative evidence produced by Riverside regarding this purported confusion. That evidence has already been discussed. It's this paid-for expert report. Obviously, I have my own opinions about that report and about the motives of the person who drafted it. Ultimately, my opinions, and I think, Your Honor, your opinions are not that crucial. What is important is that the Gaming Commission considered that affidavit. The Gaming Commission weighed that affidavit against the other evidence, including the letter from the Lynn County attorney taking this issue on directly, and the absence of any statements of confusion by Lynn County voters. After weighing that evidence, the Gaming Commission made a determination. To suggest that that decision was arbitrary or capricious is completely untenable, Your Honor. In addition to public commentary, the location of the casino is important to consider when we're addressing this purported confusion issue. What you have in front of you, Your Honor, is an overhead image of Cedar Rapids. This is a part of the administrative record. If the court is not familiar with our community, that is the Cedar River that intersects the downtown. That S-curve is Interstate 380, the most traveled thoroughfare in Lynn County. The highlighted area is the location of the casino. What you now see on the screen is what that location looks like if you were to drive by it or pass it on Interstate 380. You will know, Your Honor, that this directly abuts what I'm proud to say is now a thriving downtown community. It sticks out like a sore thumb, Your Honor. It's bare ground. It's been bare ground since 2008 when our devastating flood ravaged our city. Following that flood, this property was razed to the ground. It was subsequently purchased by the city of Cedar Rapids, and it's been held since that time for a significant development. As the rest of downtown is built up around it, that lot has remained barren. The location of the casino was very much a part of the media coverage in advance of the 2021 election. I assure you, Your Honor, that many voters on their way to the polls passed this lot, driving on 380, and thought to themselves, if we approve ongoing gaming in Lynn County, that's where the casino is going to be. Your Honor, I want to turn to Riverside's arguments regarding 99F and the ballot itself, but before we turn the page on that, I do want to just recognize that here we are in Henry County, 75 miles from Lynn County, 4 years after the election, arguing to a judge from Burlington regarding whether the will of the Lynn County electorate should be set aside. That's a troubling outcome for me personally, Your Honor. Late last week, you received some authority in the form of the Poe case. I'm sure the court has had the chance to read it. I think it's directly on all fours, Your Honor. In that case, the petitioners owned property in Lyon County, and Lyon County held a school bond election. The petitioners in that case, tax rates were impacted by the outcome of the election, and they challenged the election result. Our Iowa Supreme Court held that even though those individuals own land in Lyon County, because they could not participate in that election, they did not have standing to challenge the ballot. That law applies directly here, Your Honor, and I think If you read Poe, you'll find that the petitioner's claim there was much stronger than that of Riverside. Riverside does not own land in Lynn County. Riverside certainly is not a citizen of Lynn County, and we all know that Riverside could not participate in our election. Your Honor, I think the Poe case could be the end of this court's inquiry, but I appreciate that there are other arguments that we need to consider as well. Looking at 99F711A, which the court has seen a few times, I want to call out that I think this is one of the few non-controversial elements of this case. By, I think, everyone's agreement, only a referendum, singular vote is necessary in order to authorize gaming. We know this both because of the plain language of the statute and because the vast majority of casinos in Iowa received their license after a single ballot referendum. Further, and I think it's probably the second uncontested point in this case, there are no complaints with the 2013 ballot. Given the unambiguous language contained in this subsection, it's clear that the 2013 election was sufficient by itself to allow the issuance of a license. As such, even if this court determines that the petitioner has standing, the court need not consider anything beyond this statute. So stated simply, Your Honor, a vote approving a gaming referendum was held and the Gaming Commission issued a license. End of inquiry. Once again, I appreciate that Mr. Weinhardt has made additional arguments, so we'll move on. What appears before you now, Your Honor, is 99F711B. This is a significant statute because it is the only portion in the more than 17,000 words in Chapter 99F where the Gaming Commission is divested of authority to issue a license. You will know, Your Honor, there is clear language defining what creates that divestiture. It's subsequent disapproval. As such, the court's only ability to grant petitioners' request for relief is to hold that the 2021 ballot initiative disapproved gambling games. Let's consider the significance of that statement, Your Honor. To prevail today, Riverside must convince this court that an election decided by 10 points in favor of gaming in Lynn County should be viewed as disapproval. Your Honor, even if we accept Riverside's position that the ballot was in some way imperfect, how can an imperfect yes ever be a no? Let's look at the ballot itself. I think it can be acknowledged that as a consequence of Lynn County's reliance on the forms contained in the administrative code and distributed by the Iowa Secretary of State, there is language that was perhaps unnecessary or superfluous. Ultimately, the impact of that language was considered by the Commission and determined to be insufficient to disenfranchise Lynn County voters. What are those purported imperfections? There are a number, but given our limited time today, we'll focus on where I think the Riverside puts most of its emphasis. The first is on this issue of continued gaming in Lynn County. Riverside has suggested the proposition that Lynn County voters may have believed that they were voting not to close an existing casino. I hope I've taken that issue on directly already, Your Honor. There was not confusion. Certainly no evidence of confusion was presented to the Gaming Commission when it weighed evidence and made its determination. Notwithstanding, I think it's useful as we consider the significance of this continued gaming term in the context of the administrative code itself and in the context of other ballots that the Gaming Commission considered when determining the sufficiency of the Lynn County initiative. What you have in front of you now, Your Honor, is a Lyon County initiative. I would first note that Lyon County represents an interesting example because the casino that operates in Lyon County is owned by the same parent entity as Riverside. You will note there that the Lyon County Board of Supervisors relied on the administrative code, just as the Lynn County supervisors relied on those same code sections. You will also note that in the Lyon County ballot, there is a reference to the continued operation of gambling games. There is no dispute that gambling games were not taking place in Lyon County in 2010. For that reason, the Commission determined that the Lynn County ballot was consistent with what had been utilized in the past. I would likewise note, Your Honor, that this issue of continued should draw the court's attention to the Johnson case. It's received significant attention in the briefing, so I don't want to belabor the point. But as the court knows, the Iowa Supreme Court explicitly rejected arguments relating to voter confusion regarding the extension of utility that did not exist at the time of the election. The Supreme Court said that was not enough to disenfranchise voters. That same holding applies directly here, Your Honor. The second complaint relates to this issue of no wager or loss limits. I want to first remind the court that the reason that that language appears in the Linn County ballot is because it also appears in the Iowa Administrative Code and in the model ballots promulgated by the Iowa Secretary of State. I think, Your Honor, this is a red herring issue. An initiative allowing no limit gaming necessarily encompasses all games with or without limits. To suggest otherwise is nonsensical. Within the universe of no limit gambling are games and wagers with limits. If the ballot initiative at issue here would have been to increase the speed limit on First Avenue in Cedar Rapids from 35 miles an hour to 45 miles an hour, that speed limit is not a speed requirement. It doesn't mean that Cedar Rapids citizens would be breaking the law if they went slower than 45 miles an hour. Allowing gaming without wager or loss limits is completely consistent with the administrative code. You will note that 99F114 defines gambling games to mean, quote, any game of chance authorized by the commission. As such, adding the term no wager or loss limits as a qualifier to gambling games is completely consistent with that definition, Your Honor. To the extent the court is interested, I think the use of that term is a historical remnant. It goes back to, as was referenced earlier, the riverboat gambling games where there were wager and loss limits. When that law was changed, the model ballots in the administrative code had this language added to provide clarity to the voters. It's now a historical remnant that's not necessary, but it's certainly not inconsistent with the definition of gambling games. All right, so why did we end up with the ballot that's before the court today? The reason, Your Honor, is because the Linn County Board of Supervisors relied on the forms that were contained in the Iowa Administrative Code and that the Iowa Secretary of State distributes to local electors. The choice to rely on that language is significant, Your Honor, and the choice to hold that strict compliance is in some way necessary is, I think, somewhat remarkable, particularly coming from Riverside Casino. I would ask that the court consider the ballots in Washington County, where there is only a summary and where the target appears below that summary without any ballot language. 2 complaints Riverside has forwarded today, and the Lyon County ballot, which you've already looked at, where there's a reference to continued gaming that was not ongoing at the time of the election, and that same target issue appears again there. If we're going to require strict compliance, Your Honor, we're calling into question casinos across the state. Commissioner Burkhart, who is here and who has already been referenced today, took this issue on directly. She stated, as she spoke to her colleagues, quote, one of the factors I would have to resolve in my mind is how does that question of ballot sufficiency affect the stability of this industry if we start operating on a strict compliance type language rather than a substantial type compliance language that we've had for many years and that preceded me being on this commission. I get nervous when we start talking about strict compliance and we have licensing coming up in 2 months and what that could mean for the stability of this industry if we start operating like that. The commission weighed evidence of other ballots. They weighed the Linn County ballot and they made a determination. I'm out of time, Your Honor, but I want to leave the court with what I think the key issue today is. An imperfect yes can never mean no. Thank you.
I'll ask. I just want to check with you first. Don't start yet. I'm going to ask.
Your Honor, I'm not starting my argument yet. My colleagues have done a great job. We're no longer expected. If it's okay if I go about 4 or 5 minutes over the hour, and we'd be fine with the other side taking an hour and 5 minutes, if that's okay with Your Honor.
That's fine. Excuse me, I shared with counsel, I think before you got involved in the case, that 30 years as a lawyer before becoming a judge, I had one judge in one case in those 30 years that put time limits on the trial of the case, and I've never forgiven that judge for that, because I don't think there's any place in a courtroom for time limits as long as we're using our time wisely, and that's certainly the case here. So you're granted the 4 or 5 minutes in additional time that you need, and Mr. Weinhardt will have a similar addition.
Whatever we go over, we'll agree you could go over to. Thank you, Your Honor. I want to first start with an observation. We're having an election challenge. Riverside, an out-of-county competitor, is seeking to block a casino in Lynn County. $275 million investment, $6 million a year to Lynn County. STEM classes, theaters, twice the statutory amount. And the IRGC has talked about the 19 volumes they reviewed, the 100 live witnesses, the 400 comments, all they considered the process was months. And not 1 minute of their presentation, Your Honor, covered count 2 or 3, the supposed challenge. Not 1 minute was, this isn't great for Iowa, it's not great for Lynn County, that the IRGC didn't properly consider the effect of competition. Not 1 minute in the opening. And it's got to strike you, because I'm going to talk about why they don't have standing to do this and why the Poe case prohibits it. But just think about this. No competitor in Iowa has ever challenged a license before. No court has ever said you have standing to say you can't compete in another county. The statute doesn't create any right for a competitor to do that. The statute talks all about Iowa jobs. Are they using, is it helping the city? Is it helping the state? Is it helping our culture? There's not one word in the statute about even a competitor making a challenge. But what we have here, Your Honor, is even more severe. What we have is a competitor saying, IRGC, you don't even have the authority to issue a license in Lynn County. The other thing, Your Honor, I thought was pretty stunning, by learned, very good counsel, who we actually had a case together here in Iowa 13 years ago, and he was fantastic then, he was fantastic today. Did you hear the words count 1, count 2, or count 3? Once. There's a reason why you didn't hear that. It's because standing is evaluated by the Iowa Supreme Court by count. Iowa Bankers, the case he relies on, 3 of the 5 counts were thrown out because of no standing. And that was the Iowa Bankers Association said, look, these credit card rules harm us, Your Honor. And by the way, I'm going to talk about how they can't challenge the authority to issue the license. That doesn't cause them harm, the authority to issue a license. I'm then going to talk, Your Honor, my third point, they can't contest the outcome of a referendum. I'm then going to walk through why the IRGC's determination it was satisfied, it had authority, was entitled to deference. And finally, the key thing, Your Honor, on 6 is they're saying an imperfect approval is deemed a disapproval. Counsel didn't say that, but that's the premise. Even if you find standing, they're harmed by the agency's authority. They're injured. The IRGC made a mistake. you can actually strictly review this public law in 2020 in Lynn County, that you can do that and they can force it. Then they have to have you find that it's deemed a disapproval. The only provision of 99F that ever takes away the IRGC's authority to issue a license is actually after a license has been granted, has the county disapproved it. I think we all can agree that it was never disapproved. But let me get to the challenging the authority to issue a license. Your Honor, you know I put up 3 counts here. A competitor challenge, Your Honor, when they talk about Iowa bankers, they talk about Medco, that's count 3. That's saying you shouldn't have given Punteni, you shouldn't have given that license. You shouldn't have let that pipeline go through. You shouldn't have let this regulation go through that helps these credit unions. You shouldn't have done that because that harms me. You know, that's a hotly disputed issue. I understand their argument under 17A. No court in Iowa has ever found a competitor outside the county can block competition. And my prior counsel were correct. This is not a competition case where Iowa says we want competition. Iowa bankers, you should have a chance to compete with the credit unions. This is an out-of-state competitor saying, I want a near monopoly in my area. But interestingly, Your Honor, count 1, his entire presentation was count 1. His entire presentation is the IRGC lacks the authority to issue a license. Think of the audacity there, Your Honor. They lacked the authority to issue licenses. And what did they say, Your Honor? In our opposition to their petition, Your Honor, we had 5 pages with headings and all we could do. Standing is count by count. They have no standing for count 1. If you want to come in here and say this wasn't great for Iowa, you want to come in and say IRGC didn't properly consider the factors because this really hurts Riverside and it doesn't really help Lynn County, that's a closer call, Your Honor. That's a little closer to Iowa bankers, right? So we said, no, it's count by count. And what did we do, Your Honor? We laid out all the case law. They didn't cite a single case on count 1 authority. Not a single one. They blurred count 1 and count 3. They said Iowa bankers directly controls this case and Punteni is materially identical. Those are the 2 cases, Your Honor. Let me talk about Punteni first. This is the case that they told you is identical. Punteni is an environmental case. In Punteni, they were challenging a pipeline that went under the homes of Mr. Punteni, and then 2 members of the Sierra Club said, I use these streams, I use this recreation area, and I'm harmed too. And they presented evidence to the court that there was not only a risk of pollution, but a risk of an explosion. There's a whole separate test, Your Honor, for environmental cases. It follows the Supreme Court test in Bushby. It's not a competitor case. But interestingly, Your Honor, Punteni is not saying, Iowa Utility District, you can't ever do a pipeline. You have the power to do it. They were challenging where the pipeline went. Same thing in Iowa bankers, Your Honor. In Iowa bankers, they brought 5, the Banking Association brought 5 counts challenging credit union regulations because it was enabling credit unions to compete with them and they wanted fair competition. If you look and reread Iowa bankers, Your Honor, 3 of the 5 counts were found to be no standing for the Iowa bankers because they didn't show they were harmed for 3 of the chapters, only 1. You have to prove harm from the action you're challenging. And count 1 challenges the IRGC's authority. Your Honor, how do we know they weren't harmed by the IRGC's authority? And I'll go through this quickly because of time limitations, but we'll submit this to Your Honor. The IRGC had the authority since 2013 to issue a license. In 2014 and 17, they denied my client licenses. So in other words, you have the authority, but no license is granted. Having the authority does not injure them. In fact, the record here makes it clear they've had the authority with no injury. And Your Honor, I'd ask you to reread Kopecky in this light. Kopecky was a Lynn County resident doing a count 2 declaratory relief action. And what he said is, Supreme Court, I want you to rule the IRGC must give a license. Lynn County voted in 2013, don't let the IRGC have the discretion. So if you read Capecchi, it actually proves there's no standing here. In Capecchi, the Supreme Court says, oh no, the IRGC can either issue a license or not issue a license. They're not required to because they have the authority. In other words, having the authority to issue a license causes no injury to Riverside. They must prove it by count. Your Honor, we've cited in our briefs the Iowa Citizens for Committee Improvement and the Shandoe case. I won't spend too much time other to say the plaintiff must establish a causal connection between the injury and the conduct complained of. The IRGC having authority to issue a license does not harm them. What harmed them, if you give them count 3 standing, is there was an approval of a license, our client gets the financing, the funding, builds the casino, and then 2026 and 2027, they face potential harm because they'll lose revenue. But our having the RGs having the authority since 2013 caused them no injury because it's proven by the fact they've had the authority and they denied casinos in the past. I want to get to the contesting the outcome of a referendum. Here, Your Honor, they have a double fatal defect. They say the IRGC lacks authority, which they can't challenge because it didn't injure them. But you know why they say they lack authority? Because they're saying the 2021 Lynn County public referendum was invalid. That's what they're saying. They're challenging it. They're asking you to look at it and say, you know what, this is a defective approval. But the Poe case, and you know, they've tried to play this semantical game like, we're not challenging the referendum, we're challenging the RAGC's relying on the referendum. But necessarily they're saying the referendum was flawed and incorrect and the voters are misled. And by the way, the Johnson case, what's so important is, and that's why there's this fact-finding here, you try to determine were the voters misled. That's the test in Johnson. In Johnson, they actually said, this language is misleading. You're not extending a power plant. But hey, everybody knew. Interesting, Your Honor, I'd ask you to reread Honahan. In Honahan, the language in the referendum was completely accurate. It was $700,000 bond for a high school. But what happened there was the Board of Supervisors had earlier said, or the school board, we're going to do a bond for a full school, right? So parents are saying, hey, I got a second or third grader, I'm going to support this. And the actual bond language was 100% accurate. But there they found the voters were being misled. The key test is, are voters misled? Now, to do a contest of an election, Your Honor, these are going to be any time you are trying to show the outcome of the election was contrary to the result declared by the Board of Canvassers. So here, the Board of Supervisors in Lynn County said, we want to have a proposal to have the approval for gambling games. They then had a vote and they adopted it. So they said what it was for, and then right below it on the left, you don't see it, the full thing, it actually includes all the language, and then they approved it. And so before the IRGC, the petitioners submitted expert evidence. We think the voters were misled because, by the way, no facts, Your Honor. They didn't know about the hole in the center of the town, didn't make reference to the 100 people that spoke. No one said they're misled. It was just hypothetical. We would expect people to be misled if it says a continuance. And what did counsel say at the stay hearing? And I think he said something similar today. They're challenging the election, Your Honor. They're saying a swing of 5 points would be enough to have changed the outcome of the election. Your Honor, they're making an election challenge. But the Poe case makes it clear. And doesn't it make sense, Your Honor? Doesn't it feel a little uncomfortable? We're all here talking about what Lynn County voters thought in 2021. What does it say? Elections are the province of electors. An election contest or review of elections. Plaintiffs, though they are affected by it, stand outside the election process they seek to challenge. I submit, Your Honor, not only do they have standing because not injured, the basis for their claim is to overturn a referendum. And think about this, Your Honor. There are now roughly 20 casino operators. If you allow competitor standing on count 3, every single one will be able to argue from now on when a new casino comes. Because, by the way, the RIGC found there's cannibalization for every one of them. It's just a different number. If you give count 3 standing for any new license, they can then do a challenge. There's nothing in 99F that indicates they wanted to give competitor standing. I recognize Iowa bankers and 17 have language. It's a close call for competitor standing in count 3. But for count 1 standing, that means every one of these 20, anytime there's a new casino, they can go in and say, Your Honor, Judge Schilling, you know that 2013 referendum? I don't think it was good. The 2020 referendum, I don't think it was good. So for every one of these, they will be able to go into another county and say, we're going to fly spec the public referendum. That's crazy, right? Count 3 standings are close call. They've essentially, in their opening argument, don't even mention. I mean, that's what would make sense for you to be here, saying, you know what, let's talk about, is this in the state of Iowa's interest? Is there revenue coming in? Does this help Lynn County? Is this unfair to Riverside? Not one word. We're in a technical challenge to the RGC's authority. If this happens today, anytime there's a new casino application, you're going to have the same thing. You're going to have referendums being examined after the fact. And by the way, Your Honor, the record's clear below. The IRGC has looked at 84 referendums. So they had all that information, the Washington County, the Lyon County. They had all that before. Now, we talked about the commission's satisfied language. Let me go through that. Your Honor, this is a summary of some of the evidence that the IRGC considered. There's all citations to the record. I'm not going to go through all 10. This is applying law to facts. This is 10M. This is not the IRGC taking one ballot, looking at it and saying, oh, I don't think this is, does this pass muster? This is the Johnson test. Is it misleading? And they looked at all this information. They considered all of it. Your Honor, they even considered the declaration submitted by Riverside, where they said they thought it was misleading. And of course, you saw the letter from Lynn County, part of the evidence they considered. Again, this is 10M. They applied the record and looked at it and said, we're accepting it. Now, I want to talk about the subsequent disapproval. What they're arguing, Your Honor, is the same thing that Commissioner Ostergren said. When he voted against the license, he said, he conceded, 9F7 does not explicitly provide a remedy for a situation where an incorrectly phrased public measure is submitted to voters. He said, I must therefore decide whether the lack of reapproval is the same as a disapproval by voters in 2021. I conclude that it is. Your Honor, they took the same leap in their reply brief. They said, this is what Commissioner Ostergren meant when he stated the lack of approval is the same as a disapproval. Even if you found they could challenge an agency action of saying they have authority and saying they're harmed by the IRGC, right? That they're actually harmed by their finding the authority. And they could challenge a referendum despite the Supreme Court in Poe saying, look, it's Lynn County voters. You need 443 Lynn County voters. And they need to do it within 20 days. By the way, Honahan, Your Honor, file within 20 days, right? This is a voter within 20 days under the code. We went back to pull the briefs to reconfirm it, right? Because it wasn't clear from the opinion. This is 1,000 days later, and they're not a resident. But even if you let them go through, you have standing to challenge an agency action. You're injured by it. Poe doesn't apply. We're not going to apply 10M. I'm going to take a second look at the referendum, de novo, even though they consider all these facts. They then want you to decide that this is deemed a disapproval. Because under no circumstance, Your Honor, is this a disapproval. The voters thought they were approving. Now, Your Honor, I want to talk briefly, pull up the slides I think the 36 and 37. Our argument does not rest on, whether it was the referendum, the second referendum was in 8 years or after 8 years. The point is, Your Honor, there was no disapproval by the voters of Lynn County. But I'd like to put up, the ones about the at least 8 years. I want to respond briefly to counsel's statement that there's a change of position. My prior counsel did a great job of saying there was a second referendum done in 8 years and a second referendum is required. In their opening brief and in prior statements to this court, on 8 occasions, Council Riverside said the second referendum needed to be done in at least 8 years, okay? Not 8 years, at least 8 years. And then we said in our response, Your Honor, even if you have a problem with this 2021 referendum, it doesn't divest the RIGC of authority. There's nothing in 99F that says if you don't have a second referendum in 8 years, the RIGC can't issue a license. And so then in their reply brief, they changed. So I don't want to belabor the point, Your Honor, but in their opening brief, it said it had to be at least 8 years. And then after we said, look, at least 8 years, then how can your challenge in the 2020 referendum strip the RIGC of its authority? And then they went back in the reply and said it must be 8 years. But you don't need to hit that issue, Your Honor. I think the first point here is, and let me sum up with this. This is a $275 million investment, Your Honor, in a county that has really thought about this. And Riverside fought the 2013 referendum, which is their right, absolute right to do. They have an absolute right to do that. It's guaranteed in the state constitution, the federal constitution, freedom of speech. That's their opportunity. We applied 2014 and 17 when the IRGC had the authority, and they exercised their discretion. They had the authority. They said, nope, we're not going to do it. We kept sweetening and sweetening the offer. And the cannibalization numbers got less and less and less, which is why you didn't hear about any of it in their opening argument. So Lynn County and Cedar Rapids realized this is really good for Cedar Rapids and Lynn County. We're going to get $6 million a year. We're going to get STEM programs. We're going to get these theaters. We're going to fill this hole in our downtown. And then Riverside's backers exercised their constitutional rights to work with legislators to get a moratorium for 2 years. So the IRGC wouldn't have the authority. And that moratorium ended. It ended in June of 2024. The IRGC has the authority to issue a license. There's volumes and volumes and volumes of their consideration. And I just would submit, Your Honor, that deference needs to be given to the voters of Lynn County and to the IRGC. It was a thoughtful process. Those commissioners struggled with it, even commissioners who knew it might not be the best thing for their county. They struggled to do the right thing, and they did the right thing for Iowa. And to have an out-of-county competitor come back in and say, we're going to challenge what Lynn County voters did 3.5 years ago. When they voted to approve this, they didn't mean it. The law is clear, Your Honor. They don't have standing. The agency action didn't hurt them. The IRGC applied substantial facts to law. We get a list of 10. There's no way this was a disapproval. So, Your Honor, we request that you deny the petition. Thank you, Your Honor. Counsel, I went about 4 minutes over. Thank you.
I'll be easier to understand if I can put these papers in proper order.
Well, let's take a 15-minute recess, and before we leave, can we agree that your PowerPoint presentations will be filed in the case so that the court and the court reporter can have access to them, or is there some reason that they shouldn't be filed?
No, we would be happy with that. Yes, Your Honor, I think the parties agree. We'll file the slides we've showed, Your Honor, we'll file.
Okay. Mr. Weinhardt, you'll do the same?
Yes.
All right, that'll be the court's order then. Let's take a 15-minute recess so you can stretch and get organized. Thank you.
Just one moment, please. Thank you, sorry.
For a little over an hour, 3 extremely able lawyers have worked very hard, as they did in their briefing with their teams for each of them, to persuade the court that this is a close case. It's not a close case. And here's the first way that the court knows that this is not a close case. The most important single issue in this case is whether or not the ballot language is a match to the thing that was sought to be authorized, whether it's a match to the license issued by the Racing and Gaming Commission, or whether there was, as in Hanahan, a mismatch between the ballot language and the thing sought to be authorized. Not one of the respondent lawyers made any meaningful argument to tell this court, yes, the ballot language with its continuation language in it, the ballot language, that perfectly matched, or even it kind of matched. It was in the ballpark as the thing that was being authorized. Not one of them explained how continuing existing gambling games and initiating new gambling games could be remotely perceived as the same thing. So the other side really concedes from the get-go that there was a huge mistake in the way that this referendum is being used now by the Racing and Gaming Commission. Whether or not it was something to challenge back then, I'll talk about in a minute. But in terms of, does it authorize the commission to issue a license today, given its lack of compliance with the statute? It plainly does not. There is some brief talk from one of the respondents about the fact that there is this summary in the ballot, and that the summary language is accurate because it doesn't talk about continuation or about presence or absence of wager or loss limits. But the summary is not the thing that people voted on. The language right above the targets is the thing that people voted on. And that is clear as a matter of statute. I promise I won't do this any other time, but there are several statutes that make very, very clear, and they do apply to this election, that the summary is not what the people are voting on. It's a useful aid, but they're voting on the actual ballot language. If the court reviews our opening brief at page 18, including the footnote, we cite all of the statutes that make very clear that the summary does not count. And so it does not rescue them. We're told, well, the Racing and Gaming Commission is able to look at the facts and the circumstances of how this election happened and listen to all the comments of people pro and con about the fact of the license and so forth, and somehow intuit or get some feeling about whether public sentiment in 2021 was in favor of gaming. This idea that an imperfect yes is not a no. The question is not whether or not there was a no. The question is whether there was a yes. An imperfect yes may or may not be a no, but what the statute required was a yes. In the subsection, paragraph D, the thing that says you shall have a second election, that requires a yes. It doesn't require an imperfect yes. It requires a yes. and this concept of a disapproval or a no, they get that out of paragraph B. Paragraph B does not create a disapproval election. It doesn't create a separate kind of election. What paragraph B does is it tells you the consequence of what happens if in a second election there is a disapproval. It tells when the license winds up, when it goes away. But it doesn't create a disapproval election. So there's no question about, was there an election that had a no? The only question is, was there an election that had a yes? And given the defects in the ballot language, there plainly was not a yes. They talk about, well, there weren't affidavits, there weren't people at the public hearing who said that I was confused or something of that sort. But that, for example, in the Honahan case is not how the Supreme Court evaluated this. The Supreme Court looked at the ballot in Honahan, they looked at the bond issue and the school that the people wanted to build, and they said, do these two things match? And as a matter of law, they could say they don't match, and they are not substantially compliant with the statute enabling the election. The court is going to do the same thing here. It's going to look at the ballot, it's going to look at the license that has been authorized, and it's going to say, do these two things match? And if they don't match, then there has not been a yes. An imperfect yes is not a yes. I talked a little bit about this argument in my opening about the idea that there was lots of media coverage and the public knew whether there was gaming or whether there wasn't gaming and so forth. Whether or not the public knew how much gaming there was or how much gaming there wasn't doesn't make the ballot language compliant. The question is, as a legal matter, did the ballot comply with 99 F11 or F7 sub 11 sub D? That's the legal question the court has to answer. What people knew or didn't know that we can speculate about has nothing to do with that answer. And the ballot, as I said before in the opening argument, affirmatively misled people. Whatever people knew when they walked into the voting booth, the ballot scrambled that. And that's a reason not why we, in an evaluation of all sorts of evidence and rumors and so forth, try to intuit what it was that the public thought. That's a reason why the ballot was non-compliant with the statute. This is not an election challenge. We're not contesting the outcome to the January 2021 election. This is not a January 6th do-over or anything like that. Rather, what we're doing is contesting what the Iowa Racing and Gaming Commission has done with the result of that election. So the election is what it is. The ballot is what the ballot is. The number of votes are what they are. Those are an accomplished fact. The question is, as a legal matter, what was the Racing and Gaming Commission permitted to do with that outcome? And the time and place to challenge that outcome is when the Racing and Gaming Commission proposes to do something with it, not 20 days after the election. I'll agree with the Poe case in the sense that 20 days after the 2021 election, as a non-resident in the county, our client would not have had the ability to go file an election challenge. It didn't need to, because the day and time and place that matters is when the Racing and Gaming Commission is actually going to do something with that referendum. And I'll talk in a moment, I'll talk about standing and explain why we plainly have standing. But this isn't an election challenge, and we're not handcuffed to any of the rules having to do with an election challenge. There is the argument that, sort of as a pushback to all of the different times that the other side said that the second referendum is required, that, well, we didn't say 8 years. On a number of occasions, we said at least 8 years. Well, when we wrote the words at least 8 years, that was at a time when no one was claiming that you didn't need a second election or that the second election could be decades into the future. So we were writing that at a time when there was no dispute. There was nothing on the table having to do with that issue. Accordingly, our language perhaps wasn't as tight as it needed to be, but that language is not a waiver of the legal proposition of when is it that you need the referendum to occur, the second referendum. As I indicated in the opening argument, the better argument is the second referendum has to occur within 8 years. When you say under D, paragraph D, you have to have a second election, and then under E, you say at least 8 years, and then you have somebody who after 8 years wants to build a casino, the better reading of the statute is the election has to happen within 8 years, or at least it has to happen before the new casino is going to be licensed. And we didn't, by admission, not even knowing that the need for a second referendum was going to be an issue, change the law about that. One cannot waive what the law actually is in a statement in a brief. If someone in a brief, a tort plaintiff's attorney said, I don't need to prove causation, that doesn't change that causation is an element of a tort. If a criminal defense lawyer said, my client in custody didn't need to be Mirandized, that doesn't read Miranda out of the law. Our statement when we didn't have any idea that they were going to take this position because they had taken the opposite position all the way along doesn't amount to any sort of admission. A couple of different times we heard about these forms that were promulgated by the Iowa Secretary of State about what the ballot language ought to look like. That is an explanation of how the scrivener who prepared the ballot in 2021 went astray. It doesn't erase the mistake. It's not a justification for going astray. It just tells the story of how the mistake got made. Those forms are in the Iowa Administrative Code. Of course, the Administrative Code does not trump the statute. And so if the statute in 99F711 says one thing and those forms say another, the forms have to yield to the statute. That's true for any regulation, but it's especially true for these forms because the forms aren't even a regulation. They're a suggestion. We have to have these elections. Here, try this. And the person who drafted the ballot from Lynn County understood that the forms weren't accurate. They were way out of date because there were changes in the language that were made to those forms. The forms as written had a reference to something happening in 2010 as though 2010 is the future. And so there was an understanding that you had to tailor the forms to the facts. The problem is that the person who wrote the ballot didn't tailor the forms to the obvious fact that there wasn't gambling licensed or happening in Lynn County at the time. There is some talk about other casinos in other places, Lyon County, Washington County, or whatever. First, as the court observed correctly in the stay ruling, other licenses for other casinos are not before the court today. Second, particularly in Lyon County, the one that is most closely claimed to be like us, the circumstances were entirely different. In that county, when the second referendum happened, there was a license already issued and there was a casino under construction. To talk about continuation of gambling made some sense in Lyon County in that second referendum. It made 0 sense in Lynn County in 2021. But regardless of the facts of those other casinos or those other licensing situations, they're not precedent. It's not as though they are a ruling of some other district court that you're asked to follow. They're more just sort of trying to poke us about how maybe everything has not been done exactly consistently. And in fact, the racing and gaming lawyers are, and Jeff Peterzellik and I have known each other for many years. He's a very polite lawyer. But the Racing and Gaming Commission is politely trying to blackmail the court and saying, well, if you rule against this license and we have to strictly comply other places, there could be trouble for other casinos. Don't want to go down that road. None of that's before the court. This court has one license to decide about, and that's the one in Lynn County. I want to talk now for a little bit about standard of review, and then I'm going to talk a little bit about this standing question. So standard of review, Andrew, if you could put the statute up on the screen. We're told that the standard of review is some sort of deference to the agency's discretion because of this provision at 99F7.1 that says if the commission is satisfied that this chapter and its rules adopted under this chapter applicable to licensees have been or will be complied with, the commission shall issue a license. First, that does not trump the fact that 99F7.11 contains a legal duty. It doesn't change the only if language in the very first sentence of that provision. And the Kopecky case, which is discussed by the Commission's counsel, does not change that. In fact, I know Mr. Peterzellik litigated that case, but before Your Honor, he dances all around the key thing about the case. He talks about the platitudes in the case that espouse the great discretion that the commission has about lots and lots of things. What he doesn't say is what the Supreme Court said about the one page of statutory text that is why we're here, sub 7, sub 11. That provision is the one where the Kopecky court says that the legislature gave the commission no discretion to interpret that one. And so that's the one that is going to be interpreted by this court entirely on its own. Moreover, there are a couple other problems with this satisfaction argument. One is the commission can't satisfy itself of something that is contrary to law. So one requirement of licensees is they can't be convicted felons. Even if someone has completely turned their life around and is a completely honorable person now, and the commission wants to give that person a license, if they're a convicted felon, the law says that they can't do it. The satisfaction phrase doesn't allow the Racing and Gaming Commission to ignore a statutory command, you can't license a convicted felon. Likewise, the satisfaction phrase doesn't allow the commission to ignore the mandate for how electoral approval elections are to be conducted. Additionally, there is a limitation to that satisfaction language. The satisfaction language has to do with licensees. It doesn't have to do with elections. If one looks at the beginning of this, it says, if the commission is satisfied that this chapter and its rules adopted under this chapter applicable to licensees have been or will be complied with. So this is granting the commission discretion, although not discretion to license a convicted felon, but it's granting the commission discretion in its choice about whom to license. That language does not grant the commission discretion about allowing an imperfect yes election to be a yes election. One of the attorneys talked about the Puteni case and said, well, the Puteni case is one in which the administrative agency was granted wide discretion. But it was granted wide discretion about a particular phrase. The phrase was public convenience and necessity. And the Supreme Court said public convenience and necessity in the utility sphere is something that is committed to the expertise of the agency. The question in every event is, what statutory language are we talking about when we talk about what was delegated to the agency? And there's nothing that was delegated to the agency with regard to electoral compliance. And even if this is a measure of application of law to fact, it is a measure of applying law to fact on undisputed facts. The form of the ballot is an undisputed fact, and the court knows that in a summary judgment case, an ordinary civil summary judgment case, those are always reviewed for correction of errors at law. They are reviewed de novo because there was no dispute about the facts, and so the only question is, what is the applicable law on these facts? The same thing is true if you even consider this election question a mixed question of law and fact. Now I want to talk about the standing issue. First, remember that this is purely a statutory question, purely under the statutory grant of standing in the Iowa Administrative Procedure Act. And as I suspected, the respondents stray away from that in their arguments. One of the arguments is, well, there's nothing that confers standing on a competitor. There's nothing that gives a competitor standing to try to, nothing that gives an incumbent participant in the market standing to try to keep a competitor out of the market. That's exactly what Iowa Bankers Association did. Iowa Bankers Association sought judicial review to undo actions taken by a banking regulator that gave an advantage to a new entrant in the market, credit unions. Credit unions had the ability for the first time under this regulation to basically have the equivalent of checking accounts, and the banks didn't like that. And the Supreme Court said the banks have standing to try to keep this new entrant out of the market through judicial review. Exactly the same sort of thing that we're assailed for trying to do. So going all the way back to 1983, the Supreme Court has established a competitor does have standing to seek judicial review to do something from a market entrant that is going to hurt that competitor. Now, with regard to this idea of standing by count, the Iowa Bankers Association case and this case are entirely different on that score, and here is why. In the Iowa Bankers case, the Iowa Banking Association challenged 5 different actions that the regulator took. And some of those actions, one of those actions was dismissed out for another reason, but 3 of those actions were actions that the Supreme Court said, each of these individual actions, we can't find that you were harmed by those actions. But the last of them, the one that effectively creates checking accounts at credit unions, you're harmed by that one, so you have standing by that one. So 5 actions, each one you had to look to see, is there an economic damage to that participant? Here, there's only one action. It's the license and the resulting casino competition that that license fosters. And so regardless of which count we're talking about, it's not theory of liability, it's action by the regulator. And if there is standing for that action by the regulator, for the issuance of the license, that standing obtains to whatever theory of liability that we argue, including the theory that the referendum was unlawful. By the way, this standing by count thing was not, that I can detect, in any of the 100+ pages of briefing from anyone. That's new here. With regard to the Punteni case, first of all, Punteni is an academic discussion because remember, Punteni only matters if you think that traceability, which is a federal standard, applies to standing here. And traceability does not apply to standing here. We've indicated in our reply brief, and there's not been an argument for why that federal standard applies. But even if you didn't think about the lack of traceability under Iowa law. The two people in Puntenny who got standing were nowhere close to the pipeline. One of them lived a mile away and had a pretty theoretical fear that if the pipeline blows up, that some gas or something might come through the air towards that person. But the other was just a citizen of the state who enjoyed the outdoors and was worried that the construction of this pipeline would interfere with that individual's ability to enjoy the natural resources of the state. That was it. That was close enough for traceability purposes to allow there to be a grant of standing. Surely there is standing here. For probably as long as our republic has been in existence, but at least many decades, there has been tension between policy outcomes that people really like and laws that they think are getting in the way. Here, an executive branch agency, the Racing and Gaming Commission, saw a policy outcome in Cedar Rapids that it really, really liked. It also saw a law, 99F7 sub 11, that got in the way, that it thought was cumbersome. In 2 sentences on February 6th, the commission brushed that law aside. That was error. I understand that lots and lots of people in Cedar Rapids want this casino. I also, from the 2021 election, can see lots and lots of people, maybe not as vocal, don't want the casino. But I understand lots of people think it's a great thing for the city. And I can empathize. Cedar Rapids is my hometown. Relatives of Mayor O'Donnell were in my kindergarten class. But the law is the law. And the IRGC has not followed the law that is a prerequisite to getting to that desirable policy outcome that we want. Those laws, those procedures that you have to follow on your way to the policy outcome that people like, those are the bone structure of representative government. Those are the things that make us Americans. And that the place where those laws are enforced is in this room. It is the judicial branch that puts the brakes on and makes sure that the boxes get checked and the procedures get followed. That's all our clients are asking this court to do. The boxes didn't get checked and the procedures did not get followed under the statute this time around. There could be another time around, but this time the license was improperly granted and the grant of the license should therefore be reversed. Thank you.
Mr. Weinhardt, any other record you'd like to make in this case?
No other record other than the written filings that we've submitted and the PowerPoint that we will file pursuant to the discussion we had with the court.
Very good. Mr. Peter Zock, any other record you'd like to make?
No further record. I'll go along with what Mr. Weinhardt said and file a PowerPoint. Yes, I will ask, does the clerk prefer that those be filed as proposed exhibits? Exactly how do you prefer those to be filed?
I didn't really consider them to be exhibits. I think they can just be filed as part of the record without designating them as an exhibit. If council feel differently, and you can agree on that, I'm fine with that. But I didn't think it was an exhibit.
It's just that I think you have to pick certain categories when you're filing things. That just want to make sure we know what category.
What if we just put a caption page on the front and call it supplemental brief or something?
Is that agreeable?
Fine with me.
All right, that'll be the court's order then. Mr. Jones, anything else, sir?
No, Your Honor. Thank you for your time.
Yeah, Mr. Holscher, anything else? All right, so we'll close the record, and for you good people that aren't lawyers, I'll just take a minute. Under Iowa Court Rule 2210, it's the expectation of our Supreme Court that a district court judge issue his or her rulings within 60 days following the date the case is submitted. So the case is submitted today, May 7. We're on a fast track in this case. I'm not going to issue any promises as to precisely when I will rule, but I'll be giving this case my full and complete attention for the coming days because it's a challenge. Counsel, thank you very much for all your hard work in this case, and I issued an order earlier that I want those PowerPoints filed by a week from today, so I give you a little leeway. That will conclude the proceedings. Thank you.
Thank you, Your Honor.